actions or omissions results in harm to other people, there may be some criminal liability therein. Today on Law Express, we discuss criminal harm. My name is Noella Seidu. You just tuned into Law Express. Stay with us.
Nanabuachi Mensah Bonsu, a private legal practitioner, loves to play video games and watch movies in his free time. Randolph Chumesi Ankra, a private legal practitioner, loves to play FIFA when he's not practicing law. Noella Seidu, she's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
So, with causing harm, there's a need for us to look at the very basic element of it, which is what is harm.
Yeah.
Yes, and essentially, when we talk about harm, in layman terms, any injury to a person's body, which you can cause either with another part of your body or using a weapon, if by some means or method, be it sexually or non-sexually, you transmit a disease to somebody without the person's consent, that is also harm. And then if you use some other form of procedure or instrument to cause a disorder.
Or object.
Or object to cause a disorder to anybody, it could be temporary or permanent, that's also harm under the law. Yeah.
So now you've defined harm. Let's bring it to the point where it's now been caused. So what does our criminal law define as cause and harm?
Okay, so now as my colleague indicated, harm is caused when you either inflict some form of injury on a person without lawful authority. So when you inflict the said injury without lawful authority, the law per section 69 of our Act considers it to be an unlawful harm. And that unlawful harm per the law is when you intentionally and unlawfully inflict what has already been defined as harm on another person. It obviously, when we say it is an unlawful harm, it connotes that there are some forms of harm that the law would allow or recognizes as not falling within the scope of causing harm within section 69. And also, when you cause the harm, as has already been indicated, it must also go forward to show that before we can establish that it's an unlawful harm, then it's something that you should have done intentionally. You set out to do that particular or bring about that particular event. That is when we would say that you have in law caused harm. That's you unlawfully and intentionally causes bodily harm to somebody.
Or injury. Yeah.
Or injury to somebody, whether permanent or temporal. It wouldn't really matter the nature of the harm. It could even be just a swell on the cheek as a result of a slap. It's a harm.
Yeah.
So long as you have done something unlawfully without the consent of other person, that's also come whether, in fact, without the consent, even doctors injecting you with needles and all of that would have fallen within the scope of all this harm, because anything that leaves you with some form of bodily injury or whatever will be considered as such.
Yeah, my brother mentioned the fact that there are some lawful harm which are permissible under the law.
Yeah.
Yeah, so with that, we consider what we call generally the defenses in our criminal act. For instance, if you are protecting your body, you are attacked by somebody, to protect yourself, if you cause harm to that person who attacked you, that is lawful harm. Or if you are protecting your property, somebody trespasses onto your property or attempts to steal your property from you, and in the process of defending your property, you cause harm to that person, it's lawful, but it's subject to the harm that you cause the person being reasonable. I mean, if the person attacked you with a knife and in defense you use a stone to protect yourself and the person gets injured, it may be considered reasonable. But if just say the person attacked you with just his bare hands, and he's as slender as myself, not as strong as myself when it comes to fighting in a physical fight, then you use a gun to protect your property, we may consider your actions not to be reasonable.
Shouldn't you also consider the person's stature, the one inflicting
Exactly,
it,
that's
such that having a face-off with you, I might end up with a broken neck? So under the circumstance, the gun is the only way out.
If I have someone like, excuse me to use an example, Bukum Banku, come to my house at night and looking at me with his fists, and you expect me to go punch to punch, obviously.
But you never know. Maybe you're just as strong as he
no,
is.
I'm just admitting, there's no way I can stand him punch to punch.
So you're saying on
I'll
TV
have to
that
resort
you
to
are
other
not
means to
strong.
defend myself.
Great, we've taken notice
So
of
in that case, even though the person may be using his bare hands,
Yes.
the facts of the case are such that if I go in with my bare hands, I'll be dead. Because one punch, Mike Tyson's punch can finish you.
So you're erring on the side of caution. When I look at the definition of causing harm to another, I dwell more on the intentionality.
Okay.
In that you can still unlawfully cause harm to somebody accidentally, such that you bump into the person. That was not your intention. The issue of intentionality is very key in establishing causing harm within the context that this particular aspect of the law is defined. So we can probably take it on to the examples, how this comes to play. And readily, we are looking at female circumcision,
Okay.
or female genital mutilation, some people call it. And it has 3 variables,
Yeah.
where you excise, you infibulate, or otherwise you mutilate the whole or part of the genitalia of another person. And this is a female, like I said. We're talking about the reproductive organs, the labia minora, labia majora, and the clitoris of another person.
Yeah.
So once you do this, you have intentionally, because it couldn't be by accident that you would go through either of these, where you are mutilating, infibulating, and excising. That's a whole process. You should have thought about it and intentionally done it.
So I like to replace the word intentional with deliberate.
Okay.
So it's your deliberate action. Because if you ask some people whether they know FGM to be a crime or whether they intentionally cause harm, they will say, oh, we didn't know, it was our culture. But that notwithstanding, it's the deliberate act. The fact that you set out on a Tuesday morning or a Wednesday morning to a lady's residence or a community to take out parts of a genitalia. As you were describing it, I mean, depending on some places, they just take the labia minora or the labia majora. Some people don't even have the clitoris in their body parts. And all those who committed these acts on the ladies, rather unfortunately, they committed criminal offense.
It doesn't even matter if it's really, because there's no way, how do you explain that it wasn't a deliberate act or intentional of you to have taken a sharp object to do this, to mutilate another?
So most people will seek to justify it on the basis of
So it's
culture,
part of their defense.
But that is not a defense in law. Yes.
Perfect.
Yes, I mean, in our Ghanaian context, somebody will say, I did not intentionally do that. What they meant to say is that they did not know that it was an offense. They didn't intend to cause that offense. But in terms of the action itself, it was their deliberate action. They knew what they were doing, mostly.
Well, and it doesn't matter what your reasons were.
Yeah, exactly.
I see that Chumesi is intentionally not contributing to this aspect of the conversation, although he just wants to laugh.
When he was talking about, when you were mentioning certain parts of the body, I was getting very exciting examples. But I don't want to bring it up now. If you look at Section 69 on its own, obviously it requires 2 things. There should be an unlawful harm which should have been committed intentionally. But then if I look at Section 69A, which deals with the specific crime of FGM, that's female genital mutilation, it does not seem to even talk about intention at all.
Yeah.
And I think that this is so because we all know how grievous that practice was considered as an offensive to women and against the rights of women, among others. So I think that in the mind of the lawmaker, they didn't even want to leave room for us to go into your intention.
So you can defend yourself.
So the moment it is established that you have mutilated, you have infibulated, you have excised any part of the female's genital organ, looking at the law literally, it appears as though then you would have committed that harm
So
to the woman.
almost like a
It's a straight liability offense.
offense.
That's how it appears. So,
And then you can go to jail for it.
yeah, so I think that aside all the other crimes, FGM has been given a very special treatment where the requirement of intention may not even appear at all.
And you realize that with punishment for this particular offense, I mean, I don't normally want to go into that. You have a minimum of 3 years custodial sentence, and there's no opportunity for a fine. So you can't pay your way out of it, where they give you a fine, you pay and continue mutilating people. Okay, so use of offensive weapon
Yes.
within the context of causing harm.
Yes, so with that, it brings into what I call causing harm simpliciter, where you don't do it with any form of weapon, where, as my brother said, some muscular person...
You wrestle the person and harm him.
Yes, beats you up with his hands.
Yeah,
and
bare
no matter
hands.
the nature of the injury he causes with his hands to your person, it's just simply causing harm simpliciter. Whereas if you use an offensive weapon, so if I use a pen, for instance, to stab anybody or to stab him,
It's a pen and offensive
it
weapon,
becomes a weapon.
ordinarily.
Ordinarily, it won't be considered so, but the nature of the injury caused by it, if anything you use to cause the injury or capable of causing injury to a person becomes a weapon. And within the purposes of our Act, the Criminal Offences Act, it becomes an offensive weapon.
Let's go to the context of child danger or child endangerment, whichever way you want to look at it.
Okay, so as we had discussed, we should also know that all these particular instances you have mentioned are all some forms of unlawful harm that the law has specifically made provisions for.
Yeah.
To the person.
To the
Yeah.
person. So we have generally, you may not find slapping somebody, kicking somebody in the stomach or here as specifically mentioned crimes, but it doesn't take away the fact that they also fall within the context of
the
crime.
reason why slapping might not, because it also finds expression in other things like assault, battery, and all of the others.
That is true.
So, and it's not always that there will be harm following a slap.
Yeah, it's not always, but
So
if
that's
it
the
happens.
probable
Yes.
reason.
So I just made a point to let people understand that the fact that you don't see a particular harm being discussed here with under a specific provision does not mean that if you go ahead to do it, it will not constitute causing harm. Because these are just special cases that the law is making provision for, and they all have historical reasons to back them. Now, if you look at children, of course, I mean, in some instances, before I come there, if I may be permitted to add something, we've talked about causing harm. Sometimes, for instance, an adult can decide to even use an involuntary agent
Okay.
to cause harm.
Like
When we
a
talk
dog.
of an involuntary agent, we're talking about things that are under your control and direction. So I have a dog in my house, and I release my dog on you. I will not necessarily touch you, harm you, or do anything to you. But if I direct my dog to bite you, the dog is the one that has caused the harm. But the dog is an involuntary agent that I use as a medium to cause the harm to you. So I cannot be held to say that because I did not bite you and it's my dog that bit you, you cannot hold me responsible. In that case, I would have used the dog as an involuntary means to harm you. So I just brought that one. Now let me go to the child. Now, the law specifically makes provision for children, and I don't think that is far-fetched because children are
Vulnerable.
dependent and vulnerable.
Yeah.
So anything or any conduct of an adult that would expose a child to harm, you, the adult, to be deemed as having caused that harm. So for instance, if I sit and I direct that, okay, you don't have any child here, I direct that you go and touch the coal pot. I mean, when I know that, or touch the burner, when I know it is burning hot, and then the harm results from that, I would have exposed a child to that harm. And in fact, there's even so the law even goes on to say that where a child is mentally challenged, and you leave that child abandoned in a manner that would expose that child to harm, and harm does in fact occur, you would be responsible
Let's
for that.
break down
Yeah.
the part on the child endangerment.
Yeah.
So the first leg is a child under 12 years
Yes.
being abandoned
Yes.
or
Yes.
exposed to danger.
Danger.
The idea is that we all know that, yes, the definition of who a child is a person under 18,
Yes.
Yeah.
ordinarily.
Yeah.
But this aspect of abandoning a child under 12, okay, or exposing that child to danger is because at that age, their judgment is not very well, trusted. So a child of 13 years is allowed to babysit younger children.
Yes.
So, and that is because per the law, by 13, you can at least choose or decipher between what is dangerous. Your judgment is formed on those kind of things, what to flee from. Now, a child under 13, just 12 and below, is not given the same kind of course, we know some children are fast. I mean, street wisdom, right? Very early. But this is what the law provides. So if you expose that kind of, abandon the child, leave that child alone at home, okay, or expose them to danger, you will be committing an offense.
And to add to what you said, if you look at our Criminal Offences Act, liability only attaches to a person 12 years and above.
Yeah.
So if you are below 12 years, you can't commit a crime, strictly speaking, under our laws. But that is even besides the point. So here, if you are below 12, the law takes the view that you don't even have the mind to even make certain decisions for yourself. So such a person, if you have custody of such a person, that's a person below 12, and you fail to exercise a reasonable care that will not expose that person to certain forms of harm, and the person is exposed to that harm, then you'll be deemed to have caused harm to the person by operation of law, even though you didn't do anything. But by your failure, your omission to act,
you had a responsibility
to take care of the child.
Neglected to take care
so
of that
that
child.
by your omission, you'll be deemed
So
to have done
quickly,
that.
let's run over the part of exposing a child with a physical handicap.
You observe something. It's not necessarily even causing danger to the child. Simply abandoning the child.
Yeah, we talked about those two legs. So the first part is where you expose a child to danger or abandon the child without any care.
Yes, even makes you liable for the offense. Then, and about the handicapped children, and I realize that most people, and within our society, we tend to either look down on children with some form of growth disorders or growth challenges, and especially we have some children who are autistic and
depending on where they are on the spectrum.
Exactly. Yeah. And because of that, we have some parents generally abandoning those children or even deliberately neglecting them.
Information.
Yes.
Because they don't know how to, work with them.
Yes.
To get them to catch up.
Exactly. So for most of them, okay, you notice, I mean, in a sad experience which I have had is in dealing with, in a custody matter, one of the parents just left an autistic child and the child came up with Benz.
Oops.
Yes. So, I mean, the absence of care, and most of these children, when abandoned, go about their environment not conscious of what is happening around them. They could just touch something which is hot, or they could just fall over the staircase, or just hit something, and then hot water will pour on them. And it happens. So within that context, I think we should emphasize on the need for some parents with special needs kids to pay particular attention to them, so that they don't leave them in such a way that they end up having some physical harm.
I know Randolph wants to come in, but it's time for a break. We'll go for a quick break. Hold your thoughts.
Right.
Don't go away. This is Slow Express.
So just add on to what my colleague has said. Now, if you look at the exposing a child to danger, the first part talks about a child under 12 years.
Yes.
Now, this part does not give a 12 years limitation.
Yes.
The other says that a child for that purpose is anybody below 18. So here, and when it comes here, I mean, you notice that the law is no longer is talking about two things: physically challenged or mentally challenged. So you could, which means that a person could have their mental faculties well in place, but physically are unable to do certain things for themselves.
Yeah, because of certain restraints.
Yes. So if you expose a person who has any physical disability, let's say, for instance, I mean, you're unable to walk or even move about on your, and I carry you and I put you on the highest stairs, and I leave you there to come find your way out.
Or just not paying attention
and I
to
leave,
assist you
to come
when
down,
you know the person is constrained.
And then you attempt to come down and you fall off and you sustain some injuries. That harm will be attributed to me.
Yes.
In the other leg, mentally, of course, it goes without saying that I'm not in the right frame of mind to even make decisions for myself. And I depend on
being a child alone puts you within, to a large extent, that category where it's hard to make decisions that
For yourself.
for your own safety. So now you bring in a mental challenge.
So that's a double dose
Exactly.
of the problem.
So the childish nature is there, but then there's also that constraint. So
in such a situation, the law saddles us with the responsibility
more
of
responsibility.
ensuring that such people are not exposed to danger or harm. If that responsibility is not carried out, you, the one with oversight duties towards them, will be held responsible. So the law would deem you as the one who has caused the harm to them.
So
whether
a
you did it or
person
not.
who negligently and unlawfully causes harm to another person has committed a misdemeanor.
Yeah.
So now we need to somehow distinguish between negligence and intentionality in as brief as possible.
So you can cause harm without necessarily intending to cause the harm. But harm would have resulted anyway.
Yes.
You could have even brought about the harm out of your desire to
help.
even save life or to help.
Yeah.
But in doing that, you may have sidestepped some crucial things that needed to be done.
Or you set some things in motion that result in the exact opposite.
Yeah, so just to add to what my colleague was saying, I mean, so it's basically centers on whether you acted with some care, so carelessly or recklessly.
Due care.
Yeah, with due care. So if you be deemed to have negligently caused if in performing some acts you were reckless, and by your recklessness there's somebody or a third party who gets injured. For instance, I'll use one who controls a motor vehicle or a car. If you are driving in such a manner that you drive without caution or without care for pedestrians or other road users, and in so doing you hit somebody's vehicle which leads to the injury of another person, you would have caused harm to that other person by your carelessness or your recklessness.
So we bring it to the medical space.
Well, when you bring it to the medical space, yes, we know that for every professional, including the medical doctors, there's
And
a duty.
lawyers.
And lawyers. I mean, every professional, lawyers, medical doctors, we have a duty of care to act with the best, within the best standards. I mean, there's a standard which you are supposed to act with. Now, if you act outside that scope, or in performing your duty as the medical doctor, you fall short of that standard.
Yeah.
You would have acted negligently of your professional duty. And if somebody, by reason of this below par acts of yours or below standard duty performance of yours gets injured, then you would have caused harm negligently.
So just to add, the reason why in this particular instance the lawmaker preferred to use negligence instead of intentional, to my mind, is that, one, looking at, yes, harm has resulted from your conduct, but the question is, when we look at the chain of events, when you set out, was it part of your plans to bring about harm? No. So we are looking at what was the end goal for your acts. Was it part of the plan, or was it within the contemplation that harm would result from what it is you wanted to do?
I see it from the perspective that there should be some responsibility imposed on you, which you fail to deliver to standard. So, for instance, if you decide to be behind a motor vehicle or a steam engine, machinery, shipboat, it is expected that you should be authorized first and licensed to operate that kind of machine. And in that authorization, you are expected to have some level of professional training which qualifies you for the purpose, and for which reason some standards are expected of you. Same with a doctor. With every procedure, they have a checklist. They know what you have to do, such that if you fail to follow through and there's now harm to the person, then you have been negligent. But if you did everything by the book and still something goes wrong,
then you can't be liable.
You cannot be liable because you did everything required of you.
And also the reason why there's that distinction is we shouldn't lose sight of it. It goes to the punishment, because if the act is not intentional but negligent, then the punishment that you stand to suffer varies.
Of course.
So that is why in one breath the law says it's negligent. In another way, it says it's intentional. It's important for us to get that distinction because the mindset at
But that would be for lawyers when you're doing your defense. Let's move on to threat of harm. So you've threatened somebody with unlawful harm. You have threatened to beat up Chumesi for saying something that you don't like. And then your intention is to put the person in fear of unlawful harm. You have committed a crime.
Yes, as most Ghanaians will say, I want to put the fear of God in him. But in putting the fear of God in somebody, you will be committing a misdemeanor.
Yeah.
Yeah, and that could land you as much as 3 years in our cells.
So you're using harm to put the person in a state of apprehension and fear.
Yes.
And that is a crime in itself. How do you prove that this person is scared and in fear?
So in such an instance, it will be based on objective assessment of the facts.
Yeah.
So let's say, for instance, I get into an altercation with you and I draw a line. I tell you that if you're a woman cross the line, I'll beat you. I'll slap you mercilessly. And then I'm waiting.
Why are you threatening the
And
woman?
I'm just saying. Let's just say if you're a woman or you're a man, you cross the line. You get it?
But
and
it
I
depends
take
on
off
who.
I take off my shirt waiting for you.
And then
would you be in a state of fear or not?
I won't be in it. If it's Chumesi, I won't be in a state
No,
of
but
fear.
if it's not me, and
because I
somebody
believe I
else.
can beat you up.
So
I'll be a
so
woman
clearly,
and cross the line.
If you believe
So
you
I'm
can
not
beat me,
in
then
fear.
you couldn't have been in
This
fear.
is the point. But then I can just decide not to cross the line, go to the police, and tell them that, look, I can't even sleep at night because of your threats.
Yeah, because you threatened to beat me
And
up.
how would you
But
come
I
and
threatened,
then
you see, in that
dis-
case, I threatened to beat you up in a particular space. And
Yeah.
I drew the line at a particular location, which you didn't cross. So
Okay.
at that point in time, the question
But
would
what
be,
shows that tomorrow you come and draw one at my gate? So that is the fear.
so if I draw one at your gate, that will constitute a new set of facts, which you can
How would
base
I
on.
cross it to report to the police? I need to act ahead so you don't draw it
But
next
the
to my
question
house.
is, at the time because the law is looking at a threat that puts you in a state of fear, of harm, because the person should have done something that at that moment puts you in a particular apprehension of
I
fear.
believe that even from your analogy, of course, the person would have been in a state of fear because clearly,
if you can beat me, you know.
clearly you say if the person crosses this line, and if clearly the person cannot beat you up, I
Don't
mean, the
cross the
person
line.
doesn't even have to cross the line because the person already will be in fear of you actually
Because that
beating
person
him or her.
cannot cross the line, but you can still
You can
cross the line.
Yes.
Because you are the stronger one.
Yeah, so
But I'm
clearly,
not crossing.
You still have the capacity to cross. And it's about the apprehension, the
Apprehension.
fear.
Yeah,
of course.
You've put the person in a state where they know that you can do anything to them because you're stronger.
yeah, of course.
And then you are threatening, especially if you have a gun.
So with this law, with this particular offense, the focus is not on harm having actually been caused, but on the fact that one person's conduct has occasioned a certain degree of fear in you. So it's not like we are looking at whether you've actually suffered any harm or not.
No,
So
the threat of unlawful harm to you.
to you.
Yeah.
And that threat in itself puts you in fear.
Yes. So it has to, you must have the capacity to actually act on it.
Exactly.
Yeah.
For me, enough for me to be scared that it will
So
happen.
if the person has no means, has no capacity to carry it out, and then you yourself were not put in a state of fear, we will not even begin
So
to talk
imagine an Abuachi running to the police that a 2-year-old has threatened to beat him
about.
up.
No.
I don't think that will work.
It will not even, the police,
because the person is even
the
under
police,
12
will
years.
not, the police will not even mind him.
So we sampled people's opinion on the topic. Let's take a listen, and then after that, we react to same.
So causing harm to someone simply means to hurt or injure them psychologically, physically, and emotionally. And I think it's a bad practice for us to engage in, to decide to hurt our friends or others.
When we even look at it first from the religious angle, as a student of Islamic law, what Allah says is that for those people who harm other people, definitely they will pay for their sins. So when we also come to look at even common laws, the constitution of this country, parliamentary, legislative, our customs, and then judicial precedent, you realize that people who harm other people end up in the same situation they kept to other people.
To cause harm to someone, I believe, is to inflict pain on the person, directly or indirectly. What you think is a harmless prank can actually go in in the long run hurts the person. Like those pranks on social media where somebody is playing a prank on a person and feels like, oh, in the end, the reaction I'll get is some laughter or some joy, will end up rather hurting the person, even maybe ending the person up in hospital. Causing harm to a person can be emotional or physical. When people break up with their partner, it ends up causing harm to the person. Some people can, if the person was invested in a relationship, he or she would end up going to the extent of going on drugs. Some might even end up trying to attempt suicide because they believe that they can't live without a person. Sometimes to harm in the sense of family harm. Some family end up treating one child different from the other, and then they feel like it's a straining or something. The child will feel neglected.
In media ethics and law, when you hurt someone, you look at the reputation of the person, the extent to which you've damaged the person's reputation, to the extent that the person can even take you to the law court to sue you for the damage you've caused. So this tells us how it means to hurt someone. It's very annoying. We see people communicating false information about people. We see this kind of bullying on TikTok.
You causing harm to someone literally talks about you causing harm to the person in a physical way, emotional way, and psychological way. So when it comes to the physical part, it talks about it can talk about injuries, you causing injury to a person, and the physical pain. But with the emotion, talks about depression and anxieties.
I observed that one of the ladies who commented noted that if you defame somebody or you make statements which are defamatory of someone, it amounts to causing harm. That is not so under our law. I mean, the words of a person do not hurt.
Well, you harm their reputation. That's what she said.
Yes, harm their reputation. Yeah. Yes.
But I noticed that she kind of mixed it because it has no connection to this particular aspect of the harm that we're talking about.
That is how the person understood what it means to cause harm to another person. But I mean, be that as may, if you listen to them, you notice that they all have sketchy understanding of what causing harm is. Some of them are speaking from a point of how they understand harm to mean literally.
Yeah.
But within the context of the law, there are certain instances or there are certain particular things that would constitute harm, which may depart sharply from how we understand harm to be. So I think there was, the same person, clearly that one will not even fall within the scope of harm. If your reputation has been affected by someone's conduct, it's a civil matter purely. You cannot say that you're going to report the person to the police
criminal libel
for insulting you. We repealed that law a long time ago. We moved away from.
There was another lady.
As they say, mouth no begun.
Yes, of course. There is another lady who, in my opinion, seems to have a better understanding than most of the people.
Isn't a broken heart lady about how you harm the person?
But then before then, she did speak about, physical harm.
It's about pranking.
Yes, physical harm, which results from pranking, actually. Now, with that, it actually will fall under intentional harm.
Did you intend to harm this person?
You may not have intended to harm the person.
You intended to entertain.
Yes, but then the intention here is not your subjective intention. It's an objective test. Was it your deliberate act? Did you set out to do what you are doing, as it is? If you set out to say, I'm looking for a prank which I don't know how to describe.
So you can prank somebody in the most innocent manner, which shouldn't ordinarily result in injury. But maybe the person in reaction to your prank now gets injured by virtue of what the person does.
So, for instance, I wear scary marks.
Yes.
And
people have different ways they react to fear.
And because I am wearing the scary marks, Chumesi is about to enter this studio. And I pop up from the corner and he freaks out. And in freaking out, he hits his hand on...
He collapses. Say that.
Okay. I don't think he has a feeble heart, but I wanted to be...
You never know.
Okay, he collapses.
Chumasi can collapse for
he
like
collapses,
2 days.
He collapses, falls down, and breaks his hand. Yes. That will fall under intentionally causing harm because it was a deliberate act which has led to the injury. I say so because, in my understanding, when we look at negligently causing harm and the subsections under it, it seems to focus some on people with some skill. And I don't think anybody who take pranking as their professional work or that way they have a skill to.
There are evolution in terms of
We
work.
live in a different era.
Look
We
at
live
these
in a Gen Z
escape
world now.
artists. You know of the escape artists, those who get handcuffed, put inside water, and then they're supposed to
submerged
escape.
Those are magicians.
They are escape artists, not magic.
See, before we call them magicians, now they've given themselves a new
Those are
So
magicians.
I'm
They are
just
living in a
telling
Gen
you
Z
that
era.
there are evolutions, right? So things that before we didn't think were jobs are
Might be
actually now
jobs now.
recognized.
Oh, yes.
Yes.
Right. Okay. That's a valid point, though. That's valid.
The
Can
world
we
has- the
now?
world has changed.
Yes, the world is evolving. Can we go to causing harm by omission? Yes, we have so far discussed acts that have positively taken place, things people have done, right? Now let's take it to the context where of failing to actually act. You're required to do something, you fail to do that, and now somebody's harmed.
Well, actually, I think this aspect of causing harm is one which most people don't consider or even avert their mind to. Now, this also goes to people with some duty of care. So it focuses on parents, guardians. It also focuses on people within certain employments. For instance, prison officers, prison wardens, police officers, those people who have
Even
other
teachers
persons, even
and
teachers
caregivers.
People who have people under their care. Now, you have a duty or obligation to these persons, which include providing them with the necessaries of life, making sure that these people do not in any way injure themselves.
So before necessaries of life, there is that duty to prevent another person harm.
Yeah.
So as a parent, you're walking with a kid, you're walking by the roadside. You know this kid can impulsively run onto the road. You're required as a parent to at least hold onto the kid's hand, especially where you have to cross the street. If you fail to do that and there's any accident, you would have been a part of the cause of that harm to this person.
Of course, it doesn't derogate from the previous discussions we had about the fact that a child under 12 or a child who depends on you as a parent for his or her safety. If you are crossing the road, it's commonsensical that you would hold or assist the child to cross the road. If you fail to do that harm its occasion, you have to be held responsible.
Yes. And that person omitting to perform a duty.
Yes,
okay.
so if you fail to do that, that will fall within the concept of omission, because then by law, the law considers that you have a duty towards the child.
To prevent harm to the person.
Yes, and to
so if a
protect the
dog is
person.
attacking the child, you are supposed to prevent the harm.
Yes, defend the person. Make sure the
Chumasi
person
is looking at
make sure that the child is not in danger.
No, no.
Or don't put the
So
child in
you have to
danger.
expose yourself to the
Chumasi-
danger for the safety of the child.
Chumasi is already, I saw his face and I could tell he pictured himself climbing the wall before the kid.
no, not that. But I mean, it's an example that would not readily come to mind. Because the point is, in that situation,
You are both in fear.
You are both in fear. It depends on the kind of dog,
But
anyway.
listen.
But I think in that situation, to be very honest to ourselves, your reaction will depend on the relation you have with the child.
you
If the
serious?
child is your blood, your reaction will
A
be different.
child is a child.
No, if I mean,
No,
let's be
I mean,
honest with
you're an
ourselves.
adult. I'm being honest. It's just about who you are as a person, right? A child is a child.
Yeah, a child is a child. No two ways about that. I concede on that. But I'm saying that your reaction, the impulsive nature of your reaction, depends
So you
on.
are the teacher. You take the child on an excursion. A dog comes out. You took this child to
No,
this
but that
space.
one, of course, the
Then
child-
you jump on a fence
But
and say,
if-
"Oh,
but
it's
if
not
in the,
my child."
But if in the midst of those children is the teacher's child, her reaction will be first towards the child. That's the point I want you to. that's the
I do not
example.
entirely agree to that, but
In fact, she
we've
would do it without
seen
even thinking about it.
instances.
She would
We
do-
have seen instances where, especially in other jurisdictions, and they have these shooting incidents where people have been out there for other people's children, children that are not biologically theirs.
That's after they've saved theirs.
No, they didn't have kids there. They came out and then they protected
But
children.
But if they, my,
Indigenous
scenario,
children.
my scenario is if they had their
Their
child
kids
in
there.
there, their first reaction would be to save their children first. And I don't
So
think
the
that.
point is, you must have a duty to perform.
Yes.
for the prevention of harm to this
that-
person.
the person.
So if you are with a police officer and the armed robber shows up and the police officer decides to run away, instead of protecting you,
But the police officer
has a legal
he has a duty to protect you
Yes.
The
from
police
harm.
officer has a legal duty to protect me.
Exactly.
But you see, ordinarily, Noella, you don't have a duty towards another person's child ordinarily. Ordinarily. Because if ordinarily you don't. So
Unless there's some other reason.
Exactly,
Maybe
that will push you
are
to
a
go.
nurse, a caregiver, yes.
So if I see children playing on the field, and
there's an attack.
And there's an attack, and I fail to act, ordinarily you cannot ordinarily hold me liable unless you can find that there was a legal duty on me to perform, which I failed to do.
Yes.
That is true.
I mean, we're talking about legal duty to
Yes,
prevent
perform.
harm
To
to
prevent
another
harm.
person. So where the police officer says, look, these armed robbers, Charlie, I am not doing this for you. And then
That one is to be responsible.
The police officer
then he
is under the
boasts.
duty because of his employment.
Yes.
He
But here's a case where he hasn't been equipped enough to protect you.
In fact,
But he's still under the duty.
even if he's not on duty, he can tell you that he's not on duty. So he has no duty.
We'll go for a quick break on this note. Stay tuned. This is Law Express.
So we have been discussing the duty we have or we may have to prevent harm to another person. Now, within that concept is also the duty we have to provide to other persons what we refer to as the necessaries of life. So if the law gives you a duty to provide necessaries of life to another person and you don't do it, it will be considered as harm or failing to prevent harm to that person. Now, the question is, what is necessaries of life? We're talking about the basic needs: food, clothing, shelter, accommodation, medical or surgical treatment, amongst
Education.
others. Education, amongst others. These are all what we call the basic needs of life. And clearly, I don't even need to go into further detail. As a father or a mother, you have these duties towards your children. If you fail to do them, then you have failed to prevent harm to the child. So you'll be liable. Now, more often than not, you see adverts. Oh, we are looking for house help. And then you'll be provided with food, accommodation, shelter. These are responsibilities that you have undertaken towards the person who will come and live with you. If you fail to provide them or deny them those things that you promised, by reason of the fact that you undertook to do it, you will be held liable for failing to prevent harm. So there are several aspects of it. So in effect, but the summary of it is that if you have a legal duty to provide
The
these necessaries of life, things that makes life easy to live or makes it possible for someone to live, and you fail to provide them, you would have failed in your duty to prevent harm to those people, and then you'll be liable.
This also falls somehow under the Domestic Violence Act.
Yes, I mean, yes.
Failing to provide that is also domestic violence, and there are just too many things
Yes.
that can come
In
up
fact, in domestic
for failing
violence,
to do that.
Even if that place is very interesting. In fact, under that law, even if your wife,
That place is very interesting.
if your wife cooks and you don't eat, it's a crime. Because you would have exposed her to emotional and
Damage.
psychological damage, and it's a crime.
Yes.
If there are
But
so
it
many,
could be the other way around. If your husband cooks and you fail
if
to
your
eat,
husband cooks and you feel, whoever has a responsibility to do something for you, if they do it and you don't show the necessary care and then the necessary
and you
attention,
see,
affection,
but then there should
yeah,
be this intentionality about it, where you're neglecting to eat, not because you are too full that there's an exception, or you are not well, or you are allergic to something. But you
but
know,
not when you have called that I'm coming, I want to eat ABC, and they spend time to prepare ABC, and you come and say I want to eat.
you don't need to even call to
And
say
you did it
ABC.
for 1 week.
If every day you eat at home,
Oh, that one,
and
of
for
course, it
some
can be.
reason you're angry and then you choose not to eat,
But this one, you're angry, and the anger will cause
Cause
emotional and
emotional
psychological
pain
pain towards to the other person. I mean, that's why I said that law has very interesting provisions that we have not explored, because if people are to take advantage of it, I think almost everybody in this country will end up in jail.
I do not agree with you.
Oh, I'm telling
but
you,
I'll
you looked
push
at the
it.
provisions.
Yes,
So
I
let's
have,
look
I
at
have. I
causing
mean-
harm by hindering escape from wreck.
Yes. So with
Because we discussed domestic violence here, and I'm sure our viewers can check out our link on
All right,
YouTube for
all
that.
right.
Yeah.
yeah, so with causing harm by hindering escape from a wreck, we I mean, just to simplify it for our viewers. So let's say there's been an accident or there's been an explosion somewhere, and in your attempt to even help out, you prevent a person or a number of people from escaping or leaving that place for their own safety, and they get injured in the process. You would have caused the harm to
You
them.
shouldn't be attempting to help out. So, for instance, it's a burning house. Then you are standing at the door,
Preventing
preventing people from escaping. Or there's a car accident, people are in there screaming, they're trying to come out, then you are not helping, but busily trying to stop them from coming out. And then they get further harmed. Well,
I mean, yes, I mean, that's an aspect to it. I mean,
yeah.
So from the scenario which I gave, there comes your scenario also. So it could either be, it could either be what Ghanaians would say, a non-intentional act or a deliberate or intentional act.
With causing harm by hindering escape, it has to be intentional.
Yeah,
you are intentionally hindering the person from escaping.
I'm referring to it in the Ghanaian palette. You know, when Ghanaians will say, oh, I did not mean to do that. You may not have intended to prevent the person from coming out, but simply by being there, which is an intentional act, which prevents
or hindering them from lawful personal protection. So
you prevent the person from
protecting
themselves, or even going to somebody who can protect them.
So let's put it this way. Chumesi is in a fight with Nana Boakye, and then I'm not separating the fight too, but anytime Nana Boakye punches Chumesi, then I hold his hands behind him, so he cannot protect himself.
Yes, I think that will fall within.
That falls within the scope.
Yeah. Or there's a fight which breaks out, and then there's a police officer around, and Chumesi is running to the police officer.
Then you block him.
And I block him and push him back into the fight.
And then Nana Boakye now beats him some more.
Yeah, exactly. That will fall right into it.
Chumesi is in trouble. He's been beating a lot
But if you just stand by and keep saying yile,
no problem. Encouraging this fight.
Yeah, you're encouraging it, but the offense will not be, the crime will not be here. It will be different. Maybe you can fall under having offensive conduct, not conducive to the public, but not failing to prevent
harm to the person.
Or causing harm by hindering escape.
By hand, it wouldn't be, but it would be different. It would be a different offense.
Okay, so let's try to attempt the questions coming in by way of social media.
FGM. This happened way before I could speak or understand. I am now 32 years old and I want justice. I still do not know who did this to me, but I believe my mother should have prevented it. Can I get her arrested and prosecuted?
So the challenge with the question she poses to us is the amendment of Act 29 to include FGM.
Yes.
I think it's quite recent. It's about less than 20 years
exactly
old. So her event, at the time it took place, the question would be whether at that time it was a crime.
Yes.
If it wasn't a crime at the time, then it would be very difficult for you to even think of holding someone responsible. It means it was not prescribed by law. It was permissible. It could be done.
As a custom.
Yeah, as a custom. So if it could be done and it was done, then no crime was committed at the time. And you cannot hold them liable now.
But the other aspect we look at it, if it was within the timelines or within the period since this became, a law, then perhaps the mother owed that child that duty to protect and prevent harm.
If it was, then it is a crime. If it was within the timelines, it will be a crime.
The other aspect is where she talks about she not knowing who did it. Probably was the grandmother, but was the mother around? Did she know about it?
Yeah, so we don't have enough information to give a definitive position on it.
But ultimately, if she's 30 and this, the action predicts the law, then it's hard to follow through on that.
Yes, anyway, the way she says she wants her mother arrested.
She wants justice.
She says can she get her arrested? That connotes, I don't want to go in by
hurt.
There's some pain somewhere.
Of course, you'll be pained if you are mutilated.
She wants to get her mother arrested. That's a different angle.
For mutilating her for a crime.
My neighbors have a child of about 5 years who suffers from handicaps. I have found her at their apartment some afternoons all by herself until her parents return from work. I normally try to care for her as best as possible. I will be moving to a bigger house in a different area, but I am worried about this child. What can I do?
So from what I heard, she says the child is handicapped, and the parents clearly abandon her without any form of care. They don't
See,
provide.
the question is abandoning.
Yeah.
What qualifies as abandonment?
Yeah, and yes, and I mean the child is 5 and under 12. There are a lot of elements to it, so we can look at it from various views. Firstly, at exposing the child to danger.
Yeah.
A child under 12, she's 5 years. We are not even going to consider the fact that she's handicapped. You've left her without any form of care.
Yeah.
That is an offense. Now let's talk about the fact that you have to provide for the child. Now, as a parent, you have a duty to provide for this child. And again, you left this child without care to the extent that it's a neighbor who comes from his or her rounds to come and provide food for the child. That's also an offense. I mean, that is a form of causing harm by omission.
I didn't hear the thing of not caring for, like, of making provision.
Well,
All I see is the child being left alone all day long. And she cares for the child, but she doesn't talk about feeding, Nana. You see, the challenge with having questions come this ways, you can't even follow up to get further and better particulars to be able to come to some conclusive.
Because I find it very, well,
solution.
it could be true, but I find it very difficult to believe that someone will, two parents, father, mother, will leave a 5-year-old, go to work, and the child, their door is not locked, and the child is able to open the door, come out for you, the neighbor, to see.
Structure of the settlement, compound house. Some people make the assumption that the neighbors are there.
Maybe sometimes, if it's in a compound house, then there's a high likelihood that they may have left the child under the care of maybe a neighbor and say, oh, please, can you pay?
Or assume that because of the function of communal living, the neighbors will look out for them. You know the assumption.
Well, I mean, it is why the neighbor says that he comes back to take care of the child. I mean, that's the function of communal living.
Yeah.
And from that, I tend to infer that it's
a practice amongst them.
Where she leaves the child without necessarily providing or putting in, say, in Chumesi's hand. And then somebody would then just come and take care of the child.
That assumption and arrangement does not take away the fact that you're committing a criminal offense.
That's the point I was making.
This child has to be taken away from these irresponsible parents to some shelter.
Yes.
Under the law.
Yes. I mean, from this comment, the child is handicapped.
The shelter is a problem because in this country, you don't even have that shelter.
We have a few.
No, you know, don't.
We have a few around.
I think, is it Martin Pebu also went to court, the High Court, got an order directing the Ministry of Gender and Children to provide these things.
There are a few, but they are not well resourced. Exactly. That's the point.
So where the child is now, maybe way better than where you want to take care of the child to.
The court may order another fit family member to take over the care of that child if these people are probably incarcerated for this conduct.
What if they are the breadwinners of their respective families?
I mean, there are other fit people. The law doesn't just make it family, other relatives. Any other fit person, some people agree to foster kids.
Well,
you know, out of the abundance of the goodness.
But based on the question, based on the information that we've been supplied with, obviously, what is happening is not in the best interest of the child.
Exactly.
But we are handicapped with information also as to what the actual facts are.
Yeah.
When they
is there any arrangement and the person who is failing them?
Exactly.
That's the other question.
It's difficult to prefer.
And the handicap, what kind of handicap is it?
Is it
of course, it wouldn't matter once it's a handicap.
Maybe from a position, handicap is they don't give food, they don't give water. It could be that. They don't give
emotional support.
They don't leave her with food. She comes to give food. So it could be so many things. We don't know what the handicap entails.
You know what? Just find a lawyer near you for a proper consultation, and you'll be able to get better answers. Yeah. Gentlemen, we've come to the end of our discussion. Yes, we did not fully exhaust every aspect of this law on causing harm to person, but we at least managed to scratch the surface. Viewers, keep the conversation going. I'd like to thank Nana Boakye Mensah Bonsu and Mr. Randolph Yao Chumesi Ankra for coming by on the show. My name is Noella Seydou. Till next time, this has been Law Express. Goodbye.